Yes, Mr. Sims.
My lords, my lady, I indicated before lunch that I was going to take you through the authorities on that. Before I commence on that, I would like very briefly to take you through the factual basis of the knowledge of Zurich. It starts with the plea in the defence, which is at page 315, volume 3, tab 22, the appendices. It's very short, and to read it out, it is simply pleaded there that in view of the claimant's lack of candour in relation to a physical condition, it's not possible to accept he was in his depressive state and has been consistent, and then goes on to say the claimant has exaggerated his difficulties in recovery and current physical condition for financial gain. That, of course...
Have you a page reference for that?
Page 315, my lady.
Thank you very much.
That, of course, is supplemented by a statement of truth and indicates a positive disbelief in the claimant's case by Zurich at the time of the signature.
Sorry, 315 in which?
315. This is Appendix 3, tab 22.
Yeah. Which tab is it?
Tab 22.
Thank you. Yes.
Rather strangely numbered paragraphs.
Maybe the copying. I think it is 6, 7, 8.
It is 6, 7. 6 and 7, isn't it? Yes.
Yes.
My 6 looks like an 8.
Yes.
What that pleading indicates is not knowledge of a specific case of truth or what Mr. Hayward's true position is, but an active disbelief in the case that he's putting forward. But matters move on, and if I can direct my lords, my lady, to page 445, which is volume 3 of the appendices, tab 44.
Yep.
This is the letter from Ruth Winterbottom to Mr. Sharp. And the relevant paragraph is at the bottom of the page. Now, this sets out, because there is no finding of fact, what this sets out clearly is the matters that are in contemplation of Zurich at the time of settlement. Whether or not they believed it or knew it, they certainly contemplated it, because this is what they've written to Mr. Sharp. And they say materially there, whilst we would accept that an injury of the type sustained by the claimant could have led to a period of pain and disability, we'd expect to see significant symptoms in the early weeks, which would gradually tail off over a matter of months. At the end of the period, we'd expect the claimant would have been in the position he would have been had the accident not occurred with regard to his constitutional back problems. We would expect these back problems to be evidenced by flare-up and resolution depending on the level of activity undertaken by the claimant and whether there had been any intervening accidents or other factors which may have placed additional stress on the area of vulnerability. In essence, this is exactly the way the claimant presents after autumn 1998. And what that indicates is Zurich is at least contemplating a relatively short-term injury with recovery within a fairly short period of time. And this is borne out by what Miss Winterbottom says to Mr. Birkinshaw, the claimant's handler, which is at page 447, tab 45 in the same bundle. Where in the middle of the page, the paragraph starts, whilst it seems clear to you, me and counsel that this back injury was nothing more than a temporary exacerbation of what was a symptomatic degenerative back, Mr. Sharp had not chosen to go along with that description, but instead chosen to conclude the accident had a long-term effect on the back symptoms. So again, at this stage, and this is the last detailed evidence of what was being thought by Zurich, but again, this indicates that they have in contemplation a minor injury. What His Honour Judge Maloney eventually finds is found at page 188, which is volume 1 of the appendices, tab 5. And what he finds there,
Sorry, which paragraph?
this is paragraph 11.1.
Sorry, which tab I beg your pardon?
I apologise, my lord. This is volume 1 of the appendices, tab 5,
Yep,
page 188 in the MS numbers.
thank you very much, sorry.
11 point.
11.1, the judgment. Noting they're doing the best I can with the evidence before me, muddled as it is by Mr. Hayward's deliberate and persistent exaggeration of the symptoms, my conclusion on the balance of probabilities in respect to damage is in June 1998, Mr. Hayward suffered a significant back injury which caused him a fairly serious organic, physical pain and related disability, rendering him unable to work or materially interfering with his daily life for a period of, say, 12 months from the accident, and depression insufficient to prevent him from working or engaging in his normal activities, but sufficient to materially interfere with his natural enjoyment of them, for some 3 years from his first complaint in June 1999 to mid-2002, after which time he ceased to seek professional help. It goes on, he may also have suffered some persistent low back pain since the end of period A, again insufficient to prevent him from working or engaging in normal activities, but insufficiently material to interfere with his natural enjoyment of them. That's more likely to be the result of his pre-existing degeneration, albeit accelerated 18 to 24 months, as found by the experts. Which is fairly close to what Zurich was predicting. So whatever else may be said of Zurich in this case, they have contemplated what turns out to be the actual position found by the trial judge. And in a litigation context, that is as close to knowledge of the ultimate position as one is ever likely to get, leaving and contemplating what is actually later found by the trial judge.
Well, now, the significant difference was this, was it not? That the judge based that significantly on the evidence of the neighbours, supported by photographs showing what he'd done in 2005.
Yes.
He had that knowledge in reaching those findings. The Zurich had a belief, but didn't have that knowledge.
Yes. I accept that Zurich certainly had more evidence and a greater prospect of proving what they had contemplated when it came to trial, when the trial actually took place, than they would have done had the trial taken place in 2003. I must accept that. But what the difference is not a difference in their belief as to Mr. Hayward's injury, but a difference in their perception of their ability to prove that belief. And it's an open question whether, if their trial had taken place in 2003, what would the finding would have been. We have no way of knowing.
I thought there was... Sorry, no.
What is the question of their belief? Is it what they believed or what they thought the court would believe if the matter came to court?
Well, the question is, I say, what they believed, but it is significant for the consideration of that, whether they are deceived, whether or not the extent of the misrepresentation was not something within their contemplation. Because the Australian authorities, which my learned friend took you to earlier, and I will do so in due course, indicate that if a deception is significantly greater than that anticipated, it may still be actionable, whereas even if a fraud of some sort is considered to be the position by the representee. Hence, it is inappropriate to consider what was in the contemplation of Zurich at the time they entered into the compromise. Whether or not they believed it or could prove it is another issue. But
The issue in the end in Zurich's mind isn't ultimately, when it's considering settling a case, what it believes, but what it thinks the court will believe. Isn't it?
This was what was influencing their mind in this particular case. In hypothetical different fraud cases, Mr. Hayward's, or the claimant's, disability may be concealed in such a way that the defendant can't properly assess it. Clearly, in this case, it could properly assess it. Mr. Hayward's misrepresentations didn't blind Zurich into compromising on a basis that they hadn't considered. It forced them to compromise on the basis of what they felt they could prove.
I'm under the impression, correct me if I'm wrong, somewhere in your printed case you accepted that the settlement figure approximated to the value of the claim on the evidence as it was then available?
It represents I accept that it represents a position between what Mr. Sharp said and what Mr. Bracegirdle said, effectively based upon what a position between the two expert evidence.
That was the 135.
Well, that was the 135.
But how do we fit in paragraph the bit at the end of this judgment where the judge says it's worth 14,000 or 17,500?
Well, that still represents a quite significant injury. General damages of £17,000 is not a trivial injury, but it is much less than he obtained on the basis of the compromise. It is perfectly clear that because of what Mr. Sharp said and what Zurich thought he would say in court, they made a higher offer than they would have done had, let me put it in this way, had Mr. Hayward not made any fraudulent misrepresentations. But they also obtained a substantial discount over what his pleaded case was, of the order of £400,000. So there was a clear compromise on this, and this is one of the factors which indicates that this was a proper commercial risk-based decision by Zurich, in contrast, for example, to Carl Bay, where, as my Lord will recall in giving judgment on that, the behaviour of the loss adjuster appeared mystifying because he settled on the other side's basis with no compromise.
I don't remember.
We will come to Carl Bay in due course.
But it seems to me that in the end, particularly with a sort of insurer, what the insurer does is to say, on the basis of this evidence, this is what I think the court will do. Yeah. It's not actually what I believe, and maybe they'll have that belief, but what they're actually saying is what's the court going to believe?
Yes.
And they form the view that the court, and what may be said against you is they form the view that we settle for X because on the state of this evidence, the court will accept, or may very well accept, what the claimant says. That's really what you're doing when you settle a case. I may not believe a word of it, but I have to form a view as to what the court's going to do.
Paragraph 14 of the Statement of Facts and Issues, the settlement figure from Zurich's point of view reflected the medical evidence.
Yes.
And then explains the basis of that acceptance.
Yes. That is...
It's not saying what I'm prepared to pay for a company or what I'm prepared to do off my own bat. A settlement is, particularly when you've got somebody like an insurer, is based to a substantial extent on what it thinks the court will do in the light of the figures, in the light of the evidence.
Yes, in exactly the same way as if the representations made by Mr. Hayward were not fraudulent but merely wrong, as happens in many cases. So the approach taken by Zurich is not different, I would suggest, because this is a case of a fraudulent misrepresentation, because they are not having anything hidden. Their approach is, in effect, identical to what it would be had the same representations been made simply wrongly, which does very often happen.
That's true, but the point is if they were fraudulent, then they did base their offer on the basis of what was being said fraudulently.
But the point of principle of why fraud is treated differently is because of the concealment aspect of it. People are taken to be contracting, as compromise agreements are, on the basis of, under normal circumstances, the assumption that the other party is dealing honestly with them. In this case, Mr. Hayward was not dealing honestly with them, but they knew it. So the position that they are in is the same as if they were dealing with somebody who was simply mistaken as to the extent of
No,
his
because they even if they thought it was deceitful, their concern was that a third party, namely the court, would be deceived.
Yes.
And their concern is the same as it would be if their concern was that the third party might accept the mistaken evidence of another party.
There's a difference between deceit and mistake, surely.
There is where there's the concealment, and I think this may be the difference between myself and...
But you're focusing on, I mean, it comes down to the same point.
Yes.
The truth is being deliberately concealed from the court.
Yes, exactly.
Rather than from, I mean, if I'm the driver in the scenario about the whiplash, nobody's concealing anything from me, but the truth is being deliberately concealed from the court.
Yes, I accept that the distinction is there, but the fact that the truth has been concealed from the court is something Zurich makes clear when it pleads. So the court is not in the dark either as to there being an issue of fraudulent exaggeration in this case, and can make the appropriate determinations on that respect. In most respects, the fact that this ended up with a pleaded case, compromise afterwards, would make little difference. But the court is seized of both the claim and that particular issue when it comes to deal with its determination of it. But at the end of the day, it is not the courts that made this determination, though I must accept that the view Zurich took as the court's likely award is influenced by the representations, but it's influenced in the absence of any belief by Zurich that they were true.
It might be said that what you're doing is you're taking the most common sort of case of the contractual representation that induces somebody to enter into a contract as really being a sort of Procrustean bed, that all factual situations have to fit. And if they can't be made to fit it, then the claim has to be rejected.
Without wishing to avoid that point, perhaps it might be instructive to look at the authorities at this stage and go through and consider how the court has dealt with this issue of belief at various times in the past. And perhaps if I haven't fully dealt with your concern, my lord, I will return to it at that stage. Can I first ask my lords, my lady, to deal with, or to turn to tab 17, which I think is volume 2.
Just for you, can I just go back to the point I was putting earlier in relation to the relationship between the figures in 11.4 and the settlement agreement?
My lord.
Because they are describing an entirely different situation, aren't they? I mean, the figures in paragraph 11.4 are simply describing something quite different from the basis of the settlement.
They are describing a very different settlement sum, largely as a result of the
That
special,
case is all about
damages.
But the whole case is about the settlement
Yes.
sum. The settlement sum depends upon both sides' perception of what the court will do, which also depends upon the materials available to the parties at the time they make the agreement. And it just strikes me, at any rate, that this is a completely different ball game when it was played before the judge as compared with the discussions between in whenever it was. That's right, isn't it? I mean, they're just completely different.
The result is different because the offer that is made by Zurich, ultimately accepted, is based upon an assumption of a loss of earnings claim, which Zurich did not believe was factually justified, as we can see from the letters, but felt that the court might well accept, and hence, based on that point, the
It's on the basis that the court might well accept a wholly false claim.
Indeed, and that was the basis, and that's why I don't dispute the causation point within this, because it is perfectly clear that had the fraudulent claim representations not been made, the settlement sum wouldn't have been anything like the figure it was. Hence, there is no issue on causation. It's the belief deception issue, which is the one which is necessary for determination on issue 1. Most of the case for the appellants is put on the basis of authorities that deal purely with causation. That's not the appropriate determination. As well as causation, there must be the intermediate step of belief, in effect.
Why? If the representation fraudulent representation caused loss, and you accept causation, why must there in all circumstances be an additional belief?
Because the disbelief, or rather the deception, the belief induced, is the difference between a fraudulent claim and one that is merely wrong. It is the...
But why, if the ultimate decision is going to be that of a third party, namely the court, why isn't it justified for the defendant, prospective defendant, to say, well, I don't believe you, but I fear the court might?
And that leads them to a commercial, eyes-open settlement as to risk. And
well, that's true, but so what? I mean, the fact that it's a commercial settlement doesn't of itself... Plenty of commercial settlements get reopened for reasons of dishonesty or misrepresentation.
Yes, but for dishonesty or misrepresentation, where the dishonesty and misrepresentation has concealed something, or made it, or altered the basis of the settlement, not whether dishonesty and misrepresentation is something within the contemplation of the parties.
If the person claiming, if the insured said to the insurer, well, we'll go to court, you know I'm fraudulent, but I'm going to mislead the court and I've got all this evidence, no cause of action, and they settle because they can't prove the truth of what he said, they haven't recorded it or anything, and then later two of his witnesses turn up and say, well, actually we would have, the witness statements we produced were dishonest. There'd be nothing he could do.
I have to say that is the conclusion of my submissions, yes. It is the conclusion it comes to. But
your client got £135,000 based upon a false statement.
he got £135,000 based upon what Zurich
Otherwise,
felt
he'd
they
have got
could...
14,000 or 17,000 or 20,000 or something.
What Zurich felt they should pay in order to buy off the risk.
But on the true fact, what actually happened, though, was that they settled on that basis, and we now know that that was a false basis.
Yes, I accept that.
But if instead of saying that, instead of settling, they'd gone ahead and fought, and his dishonest evidence was accepted, and the court gave him damages and Zurich paid, and then his dishonest witnesses decided to come clean, could you reopen the judgment then? So instead of settling, they went all the way and lost because the dishonest witnesses were believed, and the dishonest witnesses then decided to come clean. Would there be power for the court to override the decision?
Yes, certainly power to do it. So that's the Latin Marshall principles, and that's.
Well, I don't think it's Latin Marshall judgment obtained dishonesty, but it's a bit odd given the present climate, which is very much to encourage settlement rather than fighting. Your approach means that if one has serious doubts about a claimant's honesty, the defendant has to fight, because if he doesn't and settles, there's nothing he can do if he turns out to be right about the claimant's dishonesty.
Settlement is encouraged in all cases, but
yes.
it isn't the... Let's remember that if this is effectively a one-sided point, because the claimant wouldn't, under any circumstances, get the opportunity to reopen the settlement, as in many cases, the suggestion that a claimant is fraudulent by a defendant is going to put pressure upon that claimant and factor into their assessment of risk and what offers they choose to accept or not accept. Now, that is likely, in many cases, to lead to a claimant accepting a discount, so they don't have to run the risk of a court saying that they're fraudulent with all of the associated difficulties that comes with. But if the claimant later comes and obtains evidence that, in fact, he can prove conclusively he was not fraudulent, not except in this case, but in other cases, he doesn't get the opportunity to reopen the settlement which has been obtained, in effect, under the additional pressure of the fraud. So what is being contended for is a one-sided advantage to defendants.
Well, it's a one-sided advantage to honest people. I mean, he doesn't get to reopen it in a situation where he's been honest, and the insurers have been honest, and they've arrived at a bargain. Two honest people.
No, but he wouldn't get an opportunity to reopen it if he were honest and had been pressured into a settlement. I'm not going to say duress, because it would be very difficult to see how you could generate duress in properly pleaded situations, but he can still be under pressure to settle when he otherwise might not. And that has the capacity to affect the honest claimant as well, because it is tempting, perhaps listening to the appellant's submissions, to assume that every time the defendant suggests that there's a fraud taking place, it in fact may not be the case. And the honest claimant, who nonetheless is potentially susceptible to allegations of fraud, needs to be protected as well in these circumstances by compromise. And I suspect this point is getting somewhat repetitious, and it may well be returned to it again, and perhaps it's appropriate to look at the authorities at this stage. If I can take Court first to Edgington and Fitzmaurice, which is at tab 17, volume 2.
Thank you.
And the page reference for the start is 875. So,
875.
875.
Yep.
The vast majority of these cases in one form or another involve shares or debentures, and I won't trouble the court with the detailed facts of this one. The relevant citation is at 891, MS 891.
Yep.
And my learned friend has taken you to this already, just above second main paragraph, halfway through. The real question, what's the state of his mind? And if his mind was disturbed by the misstatement of defendants, and such disturbance was in part the cause of what he did. Rather archaic language. And I say that the reference to a mind being disturbed is equivalent to somebody being deceived. Now, if I can take the court on to Arneson and Smith, which is volume 1, tab 3 of the authorities, and the citation and the page reference for the citation from Lord Aylesbury is 531.
Yep.
And he starts there, conceive an action deceit, like the present, is the duty of the plaintiff to establish two things. First, actual fraud, judged by the nature and character of the representations in reference to the object of which they are made, the knowledge or means of knowledge making the intention of the law which justly imputes every man, and so forth. And secondly, he must establish this fraud was an inducing case of the contract, for which purpose it must be material, and it must have produced in his mind an erroneous belief influencing his conduct. So it is supporting, in effect, an intermediate stage of belief between representation and action.
It didn't involve the question of whether a third party might believe, did it?
No, there are...
Because in this case, it's a question of the ultimate question would have been what the court believed.
And this is one where you have to read the second sentence. The Lord Chancellor said the action is one in which the plaintiffs complain that they have been deceived by the defendants and have, by reason of that deceit, lost certain sums of money and so sustained damage in an action of this character.
Yeah.
This is not a case where the Zurich said they didn't see through Mr. Hayward. They were exasperated that others didn't either.
Correct, but the elements of deceit as being set out, at least initially in these authorities, include the element of belief being induced.
Well, in factual situations where the claimant is running a case of that character.
Aside from Gip and Gip, which I will come to in due course, there are no authorities where this type of situation, one we have here, where a third party is being influenced, where the bare causation requirement is supported by any of the authorities, not as I've seen within the citations referred to by my learned friend or read within this, and my learned friend will no doubt deal with that on reply if he says there is something specific. Gip and Gip does, at least on one level, say that, and I will deal with Gip and Gip when I come to it through the medium of the extent of the deception argument. But the descriptions of the necessary ingredients of the tort where belief is an issue indicate that belief is a requirement of the tort.
But, but if you're going to take us through a succession of cases where it's a question of the defendant inducing the claimant or the plaintiff to do something or not to do something, then obviously it's a simple question of what the defendant induces the plaintiff to do. But are there any cases where the plaintiff's case is, I paid you money because I was concerned that you were going to say something which would cause me to pay you more money because somebody else would believe what you said, even if I didn't? Because if you're going to take, I quite accept that where it's a question of the plaintiff being induced to do something because of what the defendant tells the plaintiff, I can well see the force of what you say. But the spin on the ball here is that it's a question of, ultimately, in this case, Zurich was concerned what Mr. Hayward would tell the court. And the court might believe it, not that Zurich might believe it.
So there's nothing that says that in terms, but there are cases that approach it in a slightly oblique way. If I take tab 30, which is the South American and Mexican company case, this is volume 2.
Yes.
And starts at 1194.
Thank you.
This is another judgment by consent.
Yes.
Now, where in effect there was dispute about whether there was a contract at all in this case, whether or not some further sums are due under it, or whether in fact money should be returned as monies had and received. And in dealing with this, we've got the dicta of what Mr. Justice Vaughan Williams said at 1202.
Thank you.
Where he's dealing not so much with the question of deception, but the principles on which judgments by consent should be set aside. He says there, halfway down the page, under these circumstances, I've only have to consider, with reference to the second question, Mr. Morton's suggestion, judgment by consent on which the court has not exercised its mind does not and cannot raise an estoppel into parties. I can only say this is the first time I've ever heard a proposition suggested. It has always been the law that judgment by consent or default raised an estoppel in just the same way as a judgment after the court has exercised judicial function. The basis of estoppel is when the parties have once litigated a matter, it's in the interest of the estate, the litigation should come to the end, and if they agree upon a result or upon a verdict or upon a judgment, or upon a verdict and judgment as the case may be, an estoppel is raised to all matters in respect to which an estoppel would have been raised by the judgment if the case had been fought out to the bitter end.
Doesn't that slightly call into question what you said earlier in answer to a question? Does it make a difference whether you have a settlement or go all the way to judgment? In this case, wouldn't that suggest that in this case, Zurich should be in the same position in this case as if the matter had gone to judgment?
Well, the principles are slightly different because this is dealing with the situation as to not strictly of deception, but whether the compromise contract should be set aside on the basis of a pleaded case. It's the issue of what has been put in issue and therefore compromised that is before the court, not whether or not somebody has been deceived. So I accept there are slight differences, but there are, when considering the approach in respect of it, a judgment by consent, again, could be set aside on the basis of a fraud that wasn't known to the parties, in the same way as a compromise could be set aside on the basis of a fraud that wasn't known to the parties. But absent that, then the compromise is final, and that occurs in the litigation context. And where the fraud is known and expressly included within the pleadings, as in this case, then the compromise should stand because there's nothing external to the compromise on which to base the action.
But does this case focus on that?
This case is, that's the first instant judgment. The appeal starts, or very briefly, at 1205, and at 1207, Lord Herschel is saying, about halfway down the first main paragraph, roughly level with the name, I do not think that's a fair construction or fair effective arrangement of this or a judgment is given by consent. The truth is, a judgment by consent is intended to put a stop to litigation between the parties, just as much as a judgment results in the decision of the court after these matters have been fought out to the end. It would be mischievous if one were not to give a fair and reasonable interpretation to such judgments and were allowed questions that were really resolved in the action to be fought again in the subsequent action.
That again suggests that a settlement is the same as a fighting it out, doesn't it?
And where the compromise or the judgment has included the issue of the fraud, then that might well be the case that they are final. But where the fraud is external, that would be grounds for setting aside either the compromise or the judgment.
But this case isn't about anything we have to decide at all, is it?
It deals with the issue of contractual certainty, because one of the points that's raised in this appeal is dealing with Lord Justice Underhill's initial grounds for wanting to allow the initial appeal to the Court of Appeal, which is that when the parties have reached a compromise over litigation, in absence of an unknown fraud, that compromise should hold. And he then recasts his judgment in terms of deception, which was the way it was put on appeal. But in dealing with the first part of his judgment, this is, I say, a relevant authority. But if I may perhaps move on to a more specific belief authority in the grounds of litigation. This is tab 44, which is, I believe, volume 3 of the authorities.
Thank you.
Volume 3. And this is the case of Sprechedier Halbertstrom LLP and Walsh.
Yes.
Decision of Lord Justice Ward. Now, this is a litigation authority. The basis of this was that Mr. Walsh and Mr. Staines were involved in litigation. An application was made for a freezing injunction, and there was deception by Mr. Staines as to the extent of his assets, whether he could meet the undertaking for damages. Mm-hmm. Mr. Walsh was well aware that he couldn't meet the undertaking for damage, but wasn't quite sure what his financial resources actually were. Now, this led to Mr. Walsh not making an application to set aside the freezing injunction for a period of a number of months, when, had he known the true position, he could have done so earlier. And therefore he was induced by the fraudulent misrepresentations of Mr. Staines to delay seeking justice. Now, what is said by Lord Justice Ward in this case is at paragraph 17, which is page 1506,
Yeah.
he makes the rather succinct comment that a man cannot be deceived if he knows the truth. He then goes on to analyse the various statements made, and at paragraph 36, which is at page 1511, towards the bottom of paragraph 36, he notes that the stark fact remains that Mr. Walsh always knew that Mr. Staines had not been frank in material aspect and was suspicious about everything. In the course of these circumstances, he cannot my judgment have any real prospect of persuading the court he relied even partly on the prevarications and omissions.
That's the point, it's all about reliance.
Yes, but if I will find the reference within this case, it is also said within this case the fact that the court was deceived was not the point. And
It's in the middle of the paragraph.
yes, grateful to my lady.
That the court was deceived is not to the point.
Yes. In effect, he, as a result of the fraudulent misrepresentation, despite the fact the court was deceived, he wasn't, and he still delayed in making his application to set aside the freezing order. So, while rather obliquely, it was certainly thought by Lord Justice Ward in this case that the fact the court might be deceived wasn't a relevant issue. That, I have to say, is, I think, the closest on any of the authorities to the point that's...
The whole paragraph is really focusing on the point at the end, namely the reliance point, isn't it? It's just a completely different kind of case from ours.
I accept it's not the same, certainly not on all fours with this case, but there are similarities because this is a litigation context.
Yes.
There are fraudulent misrepresentations being made. The relevant point is whether or not the recipient of the representations, not the court, chose to act upon them. And to that extent, there are distinct similarities with this. The reliance of a third party on other representation is not said to be the issue. Now, except it's not put in exactly the same terms as it is in this case.
Yep.
My Lord, there are a number of authorities, I've set them out within my written submissions, which support in general terms the requirement that there be a level of deception. And on my Lord's indication, I'm not going to take you through all of them because they are on factually distinct matters. But I will, with my Lord and Lady's indulgence, take you briefly to the case of Kyle Bay, which is at tab 20, volume 2 of the authorities.
Volume 2, tab 20.
Tab 20.
Yep.
This is a decision of my Lord sitting in the Court of Appeal, giving the only judgment in this matter. The others agreed. This was a slightly strange case, not legally but tactically, where there were negotiations between the loss adjuster and the insurers as to what type of policy had been taken out. And for some reason which mystified everybody in concern, the loss adjuster chose, though he didn't believe that the insurers had provided the effectively lower returning policy, chose to negotiate on that basis and achieved a settlement on that basis while reserving his position as to try and seek some form of redress if that turned out to be wrong. Somewhat mystifying decision because it is tactically rather unsound, but in terms of the law in respect of this, this is dealt with at 951.
Yes.
And paragraphs 39 and 40 lead up to it, and the relevant parts really at 41 and 42. 41, at any rate, on the unusual facts of this case, I consider the judge was entitled to reach the conclusion he did there was no inducement in this case. I see the force of the point that the statements were to the effect of the policy, as Mr. relayed to Mr. Stafford, did induce the statement in the sense that they were a causative factor in the claimant and Mr. Diamond agreeing on a settlement figure of around 200,000 rather than 300,000. However, I think the judge effectively found that Mr. Diamond merely treated the statements as contentions which he decided to assume were right for the purpose of settlement and which he would thereafter investigate, as he did, with a view to obtaining compensation for the claimant. In effect, he chose to treat them as correct for the time being without necessarily believing they were accurate, and with the intention of investigating their accuracy and ramifications later. As already indicated, the facts of the present case appear to me very unusual, mainly, as the judge said, because the approach of Mr. Diamond appears mystifying. On the unusual facts, I think the judge's second reason was at the very least open to him, which I would venture to suggest is saying there has to be more than a mere causal relation between the representation and the action. So what was the
judge's second reason?
The second reason was that the misrepresentation was not operative because it wasn't believed.
This is not, of course, a case of fraud.
No, it's not, of course, a case of fraud. It's
Case of?
not
a case of fraud.
No. I don't think so. It's totally frightening. Don't remember a word of it. Yeah. Yes.
Well, the conclusion seems to be, and there's on both points, there weren't representations,
Yes.
but, quotes, contentions, whatever that means.
but on the basis the statements were made and they had a causal effect. Nonetheless, the fact that they weren't believed is relevant, and the mere causal effect between statement and action is not enough to generate liability.
This is my argument. I'm not saying it's a fact.
Indeed.
Yeah, well.
Yeah.
Yes.
You can conclude about my decision. Yep.
I would like to take my Lord and Lady now to Gips and Gips, which is tab 55, volume 4 of the Authorities Bundle, which my learned friend has taken.
Thank you.
My learned friend has already taken you to this authority, and the
Yes.
relevant page is at 1731,
Thank
which
you.
is the analysis.
Yes.
Now, the relevant passages, for long passages, run through B through to F, which is the analysis of this. But I preface, before I read this through, that what is at the root of this passage is the suggestion that it would be inequitable for somebody who believes there is a fraud but doesn't know the extent of it, or is surprised by the extent of it, not to have redress once they found out it was much more than they'd anticipated. Now,
Well, the submission that he's addressing is the submission at 1730C.
yes,
That's the proposition of law. And that
it
indeed
does not
is...
have to know the true position to be precluded from succeeding. Now,
And-
that's what he then addresses is saying,
But you actually submit, don't you, that the proposition at C is correct?
I have to say that the representative does not have to know the true position, but it has to be something that doesn't surprise them when they find out what the truth is. They don't have to know the true position, but it has to be within their contemplation. I'll turn to
Well, A fortiori, you would say that if the representee knows that the representation is false in some material particularly, he can't sue for fraud in respect of it.
He can only if the extent of the misrepresentation is significantly greater than that he expects. I'll come to why I say that in a moment. Or perhaps, in fact, dealing with it more directly, I'll deal with it now. I say so because of what is said in Tobiah and Schwenk, which is tab 59, the same bundle, the case starting at 1806. And this is a case on a slightly unusual particular piece of statute, which allows, in effect, recovery of damages on the basis of a fraudulent compromise or fraudulent judgment without the judgment being set aside, which is a rather unusual statutory position. But the analysis within this judgment is the same as it is in which the more general fraud situation is considered. The relevance dicta is initially at paragraph 41, which is at 1815. And the JA, and it's what's said there, in an action for fraud, a plaintiff must prove he was deceived, but need not prove he was diligent. When the action seeks the judicial rescission of a judgment, a plaintiff must prove that he and the court were deceived, and he can only do this by showing he discovered the truth since the trial. When this is done and fresh facts and material, fraud is established. Lord Buckmaster said if fraud was proved, the judgment was vitiated, he can only have meant that nothing else had to be proved apart from fraud. That means there's no need to prove due diligence as well. Now that paragraph directly supports my case, noting that there must be a deception. There's no issue that due diligence is not required in this case. It's qualified by what's said at paragraph 20 of this case, which is at page 1811,
Yes.
where Gips and Gips is referred to. And in the bottom half of that paragraph it says, Gips and Gips provides a further answer. The court there held, at 460 to 461, the representee who knows that representations were false to some extent, but acts on it nevertheless, may still establish inducement if the true extent of the misrepresentation was significantly greater than expected. And that interpretation is how I say that the passage which I took my lord, my lady, to a moment ago at 1731 should be read. Because what is being considered in Gip and Gip particularly at 1731F, it said any other where the conclusion is and the mischief is, it would mean that if a person dealing with a rogue has made to him a representation which he knows to be false but believes to be false to a particular extent, he has no right of action after making the contract in reliance upon the representation as adjusted by the representee, even though he later learnt the misrepresentation was greater than he suspected. And the analysis of Gip and Biff above that on that page, I say, is going to that particular mischief, that it is considered inequitable that there be no remedy if somebody is deceived, still deceived, to a significant extent, even if they know there's deception happening in the first place.
What do you say about the statement of law in Gips and Gips at 1731 D to E?
Question of whether the inducement is a single issue of fact.
Yes.
Yes. That, as far as I have been able to determine, is the only place that particular statement occurs. And it's just that Gip and Gip is going somewhat out on a limb on making that.
You submit it wrong.
I submit it is wrong, yes.
Yeah.
While we have the Tobiah case in front of us, it's interesting to see that they reject the proposition that proof of due diligence is required in order to set aside a judgment on the basis that fresh evidence establishes fraud. It's paragraphs 22 onwards. They treat Owen's Bank as being confined to its subject matter, which was the enforcement of a foreign judgment, and then distinguishes paragraph 27 situations where the action is to set aside a domestic judgment.
Yes.
There's quite a lot of authority referred to.
Yes, but the due diligence point isn't a point which is an issue. I am not submitting that it's necessary for due diligence, or a failure to take due diligence will allow a contract to be set aside. The proposition I'm advancing is a slightly different one, and not in respect of belief, but in respect of the substantial investigation point. And the proposition I'm advancing there is not that there's any requirement or duty to have due diligence, but if such an investigation does take place and it goes so far as to find facts which ought to have led somebody to disbelieve representation, then that is something which the representee, in fact, is taken to rely on rather than the initial representation. It is, I admit, a rather narrow application. It's probably limited to situations where, in effect, the investigation is extremely good and negligently the wrong conclusions are drawn from it. But it's a slightly different point. I'm not suggesting that due diligence is necessary.
Yeah. Yes, and Justice of Appeal Handley, which is his conclusion, paragraph 37,
Yes.
where he rejects the proposition that relief should be denied and a judgment allowed to stand because the defrauded party was careless or lacked diligence in the preparation of his case, saying that such a result would be contrary to long-established and fundamental principles.
Yes, I'm not making that submission. So it's analogous to my submission on substantial investigation, but it's not the same submission. In fact, I put the level to which their effectively reliance on substantial investigations in the absence of belief somewhat higher than a due diligence effort is not likely to occur in many situations, though in fact I would say it has occurred in this situation. Had Zurich not in effect reached the conclusions they did, they should have done on the information and investigations they have. In many respects, it's difficult to imagine a situation where representations are investigated more thoroughly than in a high-value personal injury claim, given the antagonism between the parties and the adversarial system that we have. I will briefly, without going through every authority that mentions belief, just take this court to one further authority. This is a case of BP Exploration, BP Exploration Operation Company and Chevron, which is Volume 1 of the Authorities, tab 8. Effectively of representations about who the appropriate defendant should be in an action. Now, that starts at 7:05. The passage I wish to take the court to is at MS page 744.
744.
744.
Righto, thank you.
That's paragraph 105.
Thank you.
Now, this is a recent authority, not one of the 19th century ones. At 105, as a matter of English law, a representee must always be prepared to prove the representation had an effect upon his mind. But it's sufficient to prove that representation was an inducing cause that led him to act as he did. He need not prove it was the inducing cause, the multiple causation argument of which is common ground between the parties. Now, I say the effect upon his mind referred to there is belief. And I say so because if we turn the page to 745, paragraph 106, what's said there is, although the context is different, this is right at the top of the page, I think the same principle must operate. It is sufficient for the pursuers to prove that for a period they believed that shipping was the owner and operator of the vessel, that this belief was induced by words or conduct on the part of transport and persons acting on his behalf, and that as a result they did not make any relevant claim against transport. This, of course, is again in the litigation context, though it is not, again, I accept precisely on all fours in this with this case. Nonetheless, the point of belief is being identified as a matter of law as being a component of the tort of deception. That takes me to the end of my oral review of the authorities which deal with belief. Again, there are others within my written case which I won't trouble the court with at this point. I would, however, like to take the court back to HIH briefly, if I may, and to which is volume 2, tab 19, and this to page 9.7. Which is a passage partly quoted by my learned friend in the written case.
917.
917,
Thank
my
you.
lady. What I'm turning to here is the point of principle about why fraud is treated differently. It's noted there, that paragraph. For, as Lord Justice Ricks observed more than once in his judgment, paragraphs 160, 169, fraud is a thing apart. This is not a mere slogan. It reflects an old legal rule that fraud unravels all. Fraus omnia corruptit. It also reflects the practical basis of commercial intercourse. Once fraud is proved, it vitiates judgments, contracts, and all transactions whatsoever, and Lazarus Estates is cited. Parties entering into commercial contracts will no doubt recognise and accept the risk of errors and omissions in preceding negotiations, even negligent errors and omissions. Each party will assume the honesty and good faith of each other. Absent such an assumption, they would not deal. Now, that underlies the principle why fraud is treated differently. It is treated differently because people expect each other to be honest and assume they will be. But the difference has, I say, no application in a situation where the other side is known not to be being honest about it. The point of principle is that the representee is not taken by surprise by the dishonesty of the representor. That is the special circumstance and why fraud has the status of vitiating compromises and contracts. This is, I say, something that chimes with what Lord Justice Underhill said in the Second Court of Appeal
Before we
decisions.
leave HI, it's worth reminding ourselves of the first sentence of paragraph 16, isn't it?
Yes. Yes, I agree. The public policy grounds don't permit a contracting party to exclude liability of his own fraud. But
So you can't say that the settlement agreement operated as a contractual waiver, because that would conflict with the principle that you cannot contract out of liability for your fraud in inducing a contract.
no, but it is possible to compromise an issue of fact as to whether something is fraudulent or not, in analogous to whether something is a contract is illegal or not. That can be compromised.
But if that contract itself, that contract of compromise, is brought about by fraud,
Yes.
you cannot contract out of your right to have it set aside, can you?
Yes, provided the fraud is effectively external to the contract, something hidden at the time when the compromise is made. Because if it's internal to the compromise, in the same way as if illegality is a pleaded issue in a case, the compromise can still bind the parties.
But a subsequent discovery of evidence which you didn't have at the time is hypothesized external, isn't it?
Evidence is external, but if the issue is raised squarely and dealt with within the compromise, then, unlike in the case of a judgment, the compromise couldn't be set aside, I say, on that basis. I was going to deal with this in a moment. In fact, I will deal with this now. Can I take the court to Binder and Al-Chus, which is tab 7 of volume 1 of the authorities? And this is a case of the compromise of whether or not somebody was a money lender in a loan transaction. If they were a money lender, the loan was unenforceable due to illegality, or not. Whereas the issue of whether somebody was a money lender was considered to be an issue of fact, and therefore was susceptible to compromise.
So where is this?
This is at tab 7,
Thank you.
volume 1,
Yep.
page starts at 694, and the relevant dicta, initially from Lord Denning, starts at MS 701, which is page 158 of the report.
Yep.
And what's said there at just above E, in my judgment, a bona fide agreement of compromise such as we have in the present case, where the dispute is as to whether the plaintiff is a money lender or not, is binding. It cannot be reopened unless there is evidence that the lender has taken undue advantage of the situation of the borrower. In this case, no undue advantage was taken. Both sides were advised by competent lawyers on each side. There was a fairly arguable case for each. The agreement they reached was fair and reasonable. It should not be reopened. I agree with the judge below. That's Lord Denning. Lord Justice Fillmore says, this is indeed a remarkable vehicle. No one suggests that in any way cluttered with any merits as a rider. And then goes on the following page, 702 MS at D. He says in the middle of the line there, speaking for myself, I think it's entirely plain that this was a bona fide compromise, and that there is nothing in the evidence here which could make this court say with any confidence these money-lending transactions, illegal transactions, and accordingly, it seems to me, here the court is faced with a bona fide compromise of what was a question of fact. Justice Roskill, just above of H, says, with respect, I think the argument is unfounded. Whilst it's always been the policy of the courts not to allow the money lending acts to be evaded, it's also the policy of the court to encourage compromises and enforce compromises when they are made. And he goes on the next page, after quoting...
This again is not a fraud case.
No, this is a case of illegality, where again the public policy considerations are that illegal contracts not be enforced. It's, I suggest, comparable to the fraud case because the same policy issues or similar policy issues arise. Courts should not be, and in general would not allow illegal contracts to be made in the same way as it won't allow people to rely on fraudulent contracts. But where the relevant issue is a matter of fact, is this an illegal contract or not? In this case, is there a fraud or not? Then it is possible to compromise that issue of fact, as is what happened in the compromise agreement in this case, where the issue of whether or not Mr. Hayward was a fraudster was compromised, I say, by the Tomlin order. Hence, while there are public policy arguments against fraudsters getting away with ill-gotten gains, and I accept that they are powerful arguments, where commercially astute, properly advised parties enter into compromise agreements to deal with that very issue, which is what happened in this case, there is a public policy in finality of litigation and certainty which would indicate that such compromises should be upheld. And they should only be gone behind in the situations where there has been a deception successfully perpetrated that effectively vitiates the consent of the party, which has not happened in this case because Zurich is well aware of the fraudulent nature. And this is emphasised while Mr. Hayward's representations and fraudulent ones were central to the case, conceptually, personal injury actions are very simple. You generally have, as in this case, one representation or one with nuances as to its recoverability. It is not like, for example, a share prospectus issue where there could be many facts which have different weights to different people. This is essentially a single and simple conceptual issue which was clearly put in issue and compromised, and on the basis of Zurich entering into the compromise with eyes open. Without the deception, without the concealment, the successful concealment, there's no more reason to go behind this compromise than there is a similar one when Mr. Hayward was simply wrong as to the extent of his injury. And that's not a entirely hypothetical situation. It may well be the case that a claimant asserts that they have a long-standing injury when in fact the doctors say, well, this is a 2-year acceleration injury, you've got no claim. That is potentially at least an error by the claimant, which can lead to large amounts of additional damages and could inform a compromise in the same way as Mr. Hayward's representations did in this particular case.
I see.
On an analogous note, I'm not going to take my lords and my lady to it in detail, is the case of Re John Beaufort, which is at tab 29, which is a similar point in the sense of whether an ultra vires contract could be enforced or not was considered to be an issue of fact and could be compromised, even though the ultra vires contract itself could not have been forced had it been ultra vires. If I perhaps could return to my Lord Tolson's points before lunch concerning the large number of PRA claims that could be made and what insurers might do in respect of each of them on the basis that the Court of Appeal decision was allowed to stand. A couple of points in response to that. The first is that any significant claim of a significant monetary value, or one where fraud is alleged, is likely to end up with a great deal of scrutiny in comparison with the general run-of-the-mill claim that goes before the insurers and is settled without significant investigation. Hence, the prospect of large numbers of fraudulent claims vastly inflating insurers' payouts is, I would suggest, not that much of a significant risk. The other aspect, perhaps, is this, is that we are here because not much happens where people make settlements knowing that they are being defrauded and then choose to challenge them afterwards, which is, in effect, the type of scenario that my Lord Tolson was envisaging. There are not likely to be many claims on this type of basis, simply because there have not been these in the past. We haven't had much in the way of authority even close to this case. And therefore, any consideration this might lead to a floodgates type situation, I say is likely to be unfounded. It would also be difficult on principle to confine a judgment where deception is not necessary in order to set aside judgment to personal injury type situations. It might be possible to confine it to litigation as a special case, but it's very difficult to confine it to personal injury. The difficulty is, if it is to apply in most litigation context, is that compromises become unsafe, because it is not an unrealistic fear that significant commercial enterprises, regretting a bad bargain, might wish to exert pressure in order to change that bargain. And if all they have to do is point to a statement which has been made recklessly to its truth, which may well happen a great deal in commercial negotiations, and they're entitled to set a compromise on the basis of that, or even threaten such litigation, then that is likely to lead to a blossoming of satellite litigation rather than confining it, as my learned friend suggests. In this particular case, one consider this scenario. If my learned friend is right, and the compromise in this case originally could be attacked, even though Zurich were not deceived, the subsequent case to set aside could not be compromised without the same attack being brought against that for the same reasons, that there was a compromise induced by fraud, and the cycle could potentially continue until such time as Zurich was satisfied that it had the right answer. Now that perhaps is not something that will occur in very many cases, but it nonetheless represents a risk, and it's not confined to personal injury type litigation.
No.
The relevant control over satellite litigation attempting to reopen compromises is the deception. If somebody is deceived, if something is hidden from them that vitiates what they thought was a proper and sensible compromise, but it turns out the basis is in fact not something suspected. That is the control. That's the threshold that must be, I say, satisfied before the previous compromise can be reopened, before it can be rescinded. Can I assist my lords, my lady, further on the point about deception and knowledge?
Thank you.
I've left myself relatively little time to deal with issue 2, but that's largely because a lot of what I've dealt with in terms of dealing with issue 1 has also gone to my submissions within issue 2.
Thank you.
Now, the respondent's case on that is primarily that there are many situations on the basis, particularly of the application of the two Court of Appeal authorities in this case, where different, effectively where judgments can be still set aside despite the requirement of deception. There is, in practical terms, no conflict between the decisions on the basis that what was said in this first Court of Appeal decision is correct. Then simply pleading fraud doesn't debar you from bringing a claim to set aside. What debars you is what the second Court of Appeal decision found, that at the time of compromise, you were not deceived. That's the point that debars you. So a case where a fraud is properly initially pleaded, but suspicions at that stage were allayed, perhaps by reference to the medical experts, and a compromise is entered into, would allow that compromise to be set aside because at the date of compromise, there was a deception operating to disturb the mind of the representee. Likewise, if there was still a perception in the mind of fraud, but the extent was in truth vastly greater than that anticipated, again, the original compromise could be set aside.
What if the case had been heard was being heard in front of a judge who was a judge who wore a heart on the sleeve and made it clear that, as sometimes happened in my experience, he was the only person in court who believed a particular witness. And the claimant decided, it was a claimant's witness, and the defendant decided that it was all going wrong and settled the case. The defendant didn't believe a word the witness said, but the judge did.
Yes.
And the case was going to go on for 20 days. That would be unsettleable, that would be unpickable, would it, even though the claimant didn't believe the evidence, but it was plain the judge did.
I would have to say yes, that would be unpickable in those circumstances. Again, that must follow from my submission.
I think it must, yeah.
Yes. I appreciate the unattractive nature of the point that's been led to, but it is still, prior to the judge actually giving judgment, there is always the hope in the defender that he might come to a different conclusion.
I see that. I think it's a very fair answer, and I see the matter as a matter of policy. It does seem to me to follow, and I can see it's not. It's a perfectly acceptable conclusion, but it does seem to me to follow. Yeah. Thank you.
Yes.
Sorry to interrupt.
I have, I think, reached the end of my submissions, unless there are any other points on which I can assist.
Well, I'd just like to go back to the point that's worried me considerably. I mentioned it twice already. Why can't the plaintiffs, the claimants say, you deceived me because, and the result was that because of a view I took of what the court might do, but based upon what you said, I have settled for £135,000, a claim which, if I'd been told the truth, I would have settled for about £20,000. Because the truth is what the witnesses, Mr. and Mrs. C, or whatever they were called.
Miss Cox, yes.
So, I beg your pardon, Cox.
Yes.
So now we know the truth, we know that the claim should have been settled for 20, or I suppose 30, there's obviously a bracket. Whereas instead of that, I paid £135,000, and that's because you, or your client, not you personally, obviously your client, acted knowingly and falsely in giving the material he gave to the doctors and the like.
And the
Why
reason,
can't he say that?
and the reason why you cannot set aside that is because you, when you chose to enter into the compromise, gave up not only did you agree to pay a specific sum of money, but you also chose to give up your rights to challenge the evidence and have it heard in court, to bring further evidence, to...
Well, that's because you didn't tell me the truth.
But in this case, you know that I'm not telling you the truth. So you are aware of the risks you're taking, and you choose to go ahead and settle despite knowing that risk, because you are contemplating the extent of the truth. You have an awareness of what my injury actually is. You think that you can't prove it. You choose, therefore, not to attempt to prove it, and you give up that right in return, and I give up the right to say, I am going to prove that I am innocent and I'm honest, and therefore, in return for that, I'll give up 70% of my damages, which I'm claiming, and you are going to have to pay 30% of what I'm asking for. And in doing that, you make a decision about whether to proceed, whether not to proceed, and you do it with your eyes open as to the consequences.
That depends upon how dishonest I know your client is.
I accept that that's right, and if were the case...
If the reason I don't know how dishonest he is because he's so dishonest, I don't myself see why it shouldn't, at the moment anyway, as to why it shouldn't be unpicked subsequently.
Because...
A fortiori, when we know what the true position is.
Because the position is not as you have described it. You do know how, or at least you believe that I am as dishonest as in fact I am. That's the position that Zurich finds itself in. It is contemplating how dishonest Mr. Hayward is, accurately contemplating it. It just can't prove it. It's not that Mr. Hayward's dishonesty has hidden the position from Zurich. What it's done is prevented it from proving my dishonesty, or at least or at least has made it sufficiently doubtful that Zurich chooses not to attempt to prove it.
It just seems a little illogical that if Mr. Hayward's success depends on a judge's belief as to his honesty, the fact that the person who has to pay the money, Zurich, doesn't believe him, but thinks the judge may, should prevent Zurich from claiming. I can see how if it depends on Zurich's belief, then they can't, at the one hand, say, we believed it, but we didn't believe it. But if they are paying because they are thinking the judge may believe it, why, as a matter of policy, should that prevent them from...
Because their approach is to say, we are not going to assert our right to have this tested before the judge. We are going to pay a sum of money that's less than what's being asked for in order to mitigate our potential risk on how much we might have to pay if we cannot convince the judge that Mr. Hayward is dishonest, and in fact we can't convince the judge that Mr. Sharp should be preferred over Mr. Bracegirdle, and this is a 515-year acceleration case.
What if it was a question of not a court, but Zurich simply negotiating with Mr. Hayward and thinking, well, we're not sure we believe him at all. In fact, we're rather doubtful. But we can't prove, we're not sure. And doing the best we can, we can't prove it. And therefore we're doubtful, he may be right, but we doubt it. So they settle with him, and then somebody comes out of the woodwork who they couldn't have found before, who says, I can prove he's lying. Here's the photographs, here's the evidence. Can they open it up then?
No, they can't. It's the same situation. They've made a choice about what to pursue and what not to pursue.
Very well.
Hence their position is one where they have chosen to deal with matters on the basis of compromising their risk, as indeed, of course, Mr. Hayward has as well. He has chosen to compromise his claim on the basis of receiving 70% or so less than he is asking for, and no longer running the risk that the court might find him to be dishonest. But at the time of the compromise, the question of whether or not he's dishonest is a matter of dispute between the parties. There is no decided conclusion on it. They both have arguments, and they're choosing to give up those arguments. Again, the position contended for by the appellant is that they are entitled on actually getting better evidence in order to have that set aside, where there is no such equivalent right for Mr. Hayward. And this is because it is tempting to look back on this now, knowing that the misrepresentation was fraudulent, and assume that was always going to be the case, that it will always be found to be the case. But there wasn't. There was a dispute. It was not something that was accepted.
On the true facts, he was fraudulent. He knew he was fraudulent. It was quite impermissible for him to be advancing a fraudulent case. Of course, if it was a non-fraudulent case, everything you say would be correct.
Nonetheless, the dispute was there, and from Zurich's point of view, it's effectively potentially saving itself some money if it turns out to be wrong or unable to prove its position. Mr. Hayward's point of view, he is dealing with the position, in fact, from a basis of thinking he's got away with it. But it's not possible to look at this case on the basis that we now know that Mr. Hayward was fraudulent. At the time of the compromise, that's not known. Because to look at this case and effectively say that deception is not necessary because Mr. Hayward was fraudulent runs the risk of injustice to an honest claimant in Mr. Hayward's position, who, faced with the same compromise, is then going to be in a position where he is bound, where Zurich isn't.
Yep.
Unless I can assist the court further.
Thank you very much indeed. Thank you very much, Mr. Sims.
My lords, my lady.
Mr. Lim.
Lords, my lady, it is said of Zurich that it was the victim of being placed in a commercially disadvantageous position. That much is conceded in the oral submissions. In fact, it was the victim of fraud, as found by the trial judge, whose findings are unchallenged. That there was fraud meant that Zurich were put in a position where, in reality, it did not have a choice. It is said unrealistically with respect by Lord Justice Underhill, paragraph 16, an ultimate sentence of that paragraph in his judgment, that here Zurich could have taken the case to trial in order to disprove the statements in question.
Yeah.
In reality, this wasn't any more on account of Mr. Hayward's successful fraud as it then stood, an exercise in risk analysis. This had become a one-way bet. And the only risk to be assessed was who was going to be preferred, Mr. Bracegirdle or Mr. Sharp, according to their different views of the period of future losses. In reality, the truth of the matter, unknown to Zurich, is that there were no future losses. And that is why we've said that not only quantitatively but qualitatively, this was a wholly different claim. And that is reflected by the numbers, yes, but that also is the stark reality of the position. My Lord Toulson referred earlier in this afternoon's argument to there having been a concession by the respondent about how matters stood at the time it was settled. That is found partly in paragraph 14 of the Statement of Facts and Issues. My Lords, my Lady, it is also found at paragraph 79 of the respondent's printed case at 110, where it is accepted, last sentence, that having offered to pay what it did, which Mr. Hayward eventually blinked and accepted, that was a sensible estimate of loss based on an assessment of the expert evidence. So that is the concession, paragraph 79, MS 110.
Yes.
To be clear, knowing
we submit means knowing the truth. It doesn't mean, as it subsequently turns out, having guessed right. That really is what my learned friend's submission comes to in terms of a definition of knowing. I deal very shortly, if I may, with three of the authorities that my learned friend has taken the court to. The first was Sprecher. This, the court will recall, involved the judgment of Lord Justice Ward.
Yes.
That judgment is to be viewed in the context of what Lord Justice Ward said at paragraph 7.
Can you remind us of the page number?
So sorry,
Tab number.
it's 1506.
Thank you.
So AV3 tab 40. And as I say, it's all of the findings that the Lord Justice expresses.
Which paragraph?
I'm so sorry, paragraph 17.
Thank you. That's page 1506, I see. Thank you.
1506,
Yep.
and this is the pithy statement, a man cannot be deceived if he knows the truth. And the finding that the Lord Justice eventually reached about the representee in this case is that he did know the truth. So it isn't a belief case, it's a knowledge case. What Lord Justice Ward was meeting at paragraph 36 was the gravamen, as it's put, this is the second sentence at the foot of 1510, the gravamen of the claimant's case is that he was deceived into believing that Mr. Staines was in a financial position to meet his undertaking.
But he knew he wasn't.
Damages. And he finds he wasn't.
Right.
He wasn't at that stage is saying some definition of the
So your point is
ingredients
he
of the
wasn't, it wasn't a case where he was concerned the court might accept the evidence. That's your point. It was a straightforward representation to him, which he didn't believe.
Correct. And he was also dismissing the assertions of of the representee that he was a believer, because if we go 4 or 5 lines down from there, as far as Mr. Walsh was concerned, Mr. Staines had lied about his financial position. He had a substantial liability and was insolvent. He never wavered in that belief. At that point it says belief. He knew from the beginning of the litigation that the truth had not been told. The passages I've emphasised in the preceding paragraphs make that clear beyond
But isn't that quite dangerous for you? Because this says what he believed, and the evidence in your case is you didn't believe them.
No, but what I'm saying, my Lord, is that the Lord Justice is there simply dealing with what had been the case put on behalf of the representee.
Your point is that it's not a concern about what the other party is concerned about a third party believing.
That, and also when one actually looks at the findings of fact as they come to be expressed by Lord Justice Ward, first of all, he is dismissing the suggestion that there was belief, and secondly, he is in effect finding, one sees it 5 lines from the bottom, Mr. Walsh always knew that Mr. Staines had not been frank in material respect. And that is simply not Zurich's position. The second authority is Kyle Bay. So far as that is concerned, again, the court wasn't concerned with the issue of belief. All that happened there is that the representee assumed that what had been said to him was correct. No more and no less. So there wasn't, by my Lord, as a Lord Justice, any addressing of the ingredients of the issue of what are the elements of deceit, and in particular whether belief is a necessary ingredient. There is then the BP Chevron case, and that, my Lords, my Lady, we know is in Authorities Volume 1. And again, the crumb of comfort that the friend seeks to take from this is that at one point in the judgment, Lord Millett uses the word believed, but he's not actually there saying that belief is a necessary ingredient. It is simply that, in that case, which was actually concerned with limitation, it formed part of the pursuer's case to say that it believed that shipping was the owner and operator of the vessel. It does no more than that. And we can see that that was their case from paragraph 23 within the judgment of Lord Hope, because he explains there that they say they were first induced by shipping on behalf of transport into the erroneous belief.
Is this page 719?
This is 719, yes.
Sure.
Lords, my lady, I don't propose to traverse, as it were, any further the Kyle Bay case or indeed the Binder case. I just draw to the court's attention where we deal with those authorities in our printed case. Kyle Bay is at paragraphs 44 to 46 of our printed case, and so far as Binder is concerned, that is at paragraph 93 of our printed case. We do, though, I think, let me take you, if I may, briefly just to one part of that, at paragraph 93, page 74. This is within the core bundle.
Thank you. Which page? MS?
MS 74.
Thank you. Yes.
And it's simply to underscore at this stage in proceedings that which is in any event underlined. This is the discussion of Professor Buckley of the Binder case in his book on illegality, and at the very end, it would not be right to allow the public interest as reflected in principles of illegality to be circumvented merely by an agreement between the parties. If there is any serious likelihood of that interest being adversely affected, it would be the duty of the court, notwithstanding the undoubted strength of the policy of encouraging settlements, to allow the issue to be open. Lords, my lady, the last authority that I ask you to look at on one last occasion is that of Tubier and Schwenker.
Is?
And this is the Authorities, Volume 4, at tab 59. And in a sense, this does take us into a litigation context. This is an authority that, in my understanding, my learned friend may have been prompted to refer to, given our reliance on GIPS.
Yes.
You will see, Lords, my lady, that the court there was concerned with the first action attaching to section 66 of an Australian statute, which allowed, in effect, a claim for restitution on the part of a motor insurer where it emerged that a payment having been made, the claimant securing that payment had in fact been dishonest in a material respect, and that is set out. The text of the section is at section 66-1806. As to what ensued in terms of the particular facts of Tubier and Schwenker, that is briefly traversed by Mr. Justice Handley at 1808. It's explained there, the proceedings arose out of a motor vehicle accident on 31st May. The appellant brought proceedings. There was then an arbitration, and neither side, so to speak, appealed against the findings or sought any form of rehearing. It turned out, though, in that case, that there had been a fraud. At paragraph 15, therefore 1810, Mr. Justice Handley cites from the edition Spencer, Bauer, Turnley and Handley as it then was. You have the current edition again in the Authorities bundle, but it concludes, as one can see at the foot of that page, the representee's knowledge of the truth must be full and complete. Partial and fragmentary information or mere suspicion will not do. Over the page at paragraph 16, it's recited that the judge's findings established that the insurer did not have full and complete knowledge of the original plaintiff's fraud before the receipt of Mr. Mortar's report, The insurer certainly had suspicion, doubt and mistrust, but that is not enough.
Yeah.
And then we come, please, to paragraph 20. Now, my learned friend invited the court's attention to the last part of that paragraph. Can we, though, begin at the beginning of that paragraph? Yep. Mr. Williams submitted that the insurer knew after the arbitration that Mr. Toubier had attempted to defraud it, and this knowledge was sufficient to bar it from relief under Section 66. However, the insurer's knowledge at the relevant times was incomplete, and the then plaintiff obtained no financial benefit from the fraud that was exposed at the arbitration. Now, the analogy is not a perfect one, but one could say that given that the settlement was a fair assessment on the evidence, there was a benefit, yes, to Mr. Hayward, but he'd got no better than the evidence then allowed. The financial benefit he did obtain was obtained from the fraud that was not then exposed, and that is precisely the situation we have here, because it wasn't then exposed that, in fact, long before the settlement, he was, so far as accident-related symptoms are concerned, fully recovered. These conclusions answer this submission. And then we come to the passage which my learned friend has already cited, which takes us back to Gips and Gips. All that I say about that, having said that Toubier would be the last authority, forgive me, counsel's promise yet again broken, is that the passages that inform what Mr. Justice Handley says at Toubier and Schwenker do take us on to page 461, and I think for the sake of completeness, I ought to just place that before the court. So 461 within the report in Gips is in fact found in our bundle at MS 1732. And this is, in fact, a passage I don't believe in argument we have gone to, and it's what appears below letter B. The only way in which the decision of the trial judge on this issue can be effectively attacked would be to show that the respondent understood completely the extent of her husband's misrepresentations, or possibly that the difference between what she understood and the extent of his misrepresentations was so minute that His Honour should have decided that it was irrelevant. And it is that passage, ultimately, which one suspects Justice Handley had in mind when alluding back to Gips. My lords, my lady, that completes such review as I want to undertake of the authorities. Is there then any other matter on which I can assist?
Anything you want to? Thank you very much indeed, Mr. Well, we're very grateful to you for your oral arguments today, and we are very grateful to all those who are involved in preparing the written cases. We will consider this matter and let you know our decision in due course. The court is now adjourned. Thank you again.